The defendant Charles Garley appeared before Judge Boyd in a Texas courtroom to answer a charge that carried the possibility of changing the course of his life. Represented by defense attorney Daniel, Mr. Garley faced a second-degree felony allegation of assault on a peace officer or judge causing bodily injury, an offense punishable by up to 20 years in prison under Texas law. At first glance, the hearing seemed routine. The plea agreement had already been negotiated. The paperwork had already been signed. Both sides appeared ready to move forward. But as this case unfolded, it became clear that the courtroom's focus would extend far beyond the charge itself. What began as a standard plea hearing soon turned into a deeper discussion about responsibility, relationships, family, and the choices that often determine whether a defendant succeeds on probation or eventually finds himself back before the court. As you'll see in this hearing, Judge Boyd carefully examines not only the legal requirements of the plea agreement, but also the underlying issues that brought Mr. Garley into the criminal justice system in the first place. Throughout this case, we here at Case Storm will break down the statutes, legal procedures, court admonishments, deferred adjudication rules, probation conditions, and constitutional rights involved, explaining them in plain language so that every viewer can understand exactly what is happening and why. Because by the end of this hearing, the most important question will not be whether Charles Garley accepts a plea agreement. The real question is whether he can avoid making the kind of mistakes that could transform a second chance into a 20-year prison sentence. Let's step inside the courtroom.
Court is calling 2021 CR 7282, State of Texas versus Charles Garley. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Mario Moreno for the defendant.
Are you Mr. Garley? Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garley, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? Yes. I'm searching for the indictment. Oh, that's okay. Oh, you know what? I found it. Thank you. No, I knew you had. You're always awesome. Mr. Garley, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we're waiving count one, proceeding on count two.
Any objection?
No objection. Your Honor.
Mr. Garley, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of assault on a peace officer or judge causing bodily injury? As a second-degree felony, the range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Notice how carefully the judge is walking the defendant through every constitutional right before accepting the plea. This is not just courtroom procedure, it is a legal requirement. Under Texas Code of Criminal Procedure Article 26.13, the court must ensure that a defendant understands the charge, the punishment range, and every consequence of entering a plea. The judge is also protecting rights guaranteed by the Fifth Amendment and Sixth Amendment, including the right to remain silent, the right to confront witnesses, and the right to a jury trial. If these warnings are not properly given, a plea can later be challenged as involuntary.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Garley, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea, there's a $300 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
The discussion about appeal rights may sound routine, but it carries enormous legal consequences. Under Texas Rule of Appellate Procedure 25.2, defendants who accept plea bargain agreements often waive most of their appeal rights. The judge is making sure Mr. Garley understands that once this plea is accepted, his options to challenge the case later become extremely limited. Courts take these waivers seriously because appellate rights are considered significant constitutional protections.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 2 years. There be 100 hours community service restitution, no contact with Gabriel Ortelajo, Artalejo, and Aaron Dial, Dial, and anger management. Did you understand those are recommendations from the state? And the court does not have to follow those recommendations. Then to the offenses charged in count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Your Honor, state all overstates Exhibit 1 and all attachments.
No objection.
All right, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review this document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there would be no live testimony? Did you understand?
Yes.
All right, the state you may be excused. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court would defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Not at this time.
Mr. Garley, are you still with the person who's listed as your girlfriend in here? All right, so what steps have you all taken to handle your, I don't want to say disagreements, but your discussions differently? No,
No.
I'm talking about the facts of this case. The police came to your door, not because, hey, we're just walking around. This is like a door we should knock on. I've read in the police report that there was some issue and you wanted her to leave. So she's calling her family saying, I'm leaving.
Notice that the judge does not immediately enter a conviction. Instead, after reviewing the evidence, the court finds there is sufficient evidence to support guilt but chooses to defer that finding. This authority comes from Texas Code of Criminal Procedure Article 42A.101. In other words, the defendant is being given an opportunity to prove that he can follow the law and successfully complete supervision. It's a second chance, but one that comes with strict conditions and potentially severe consequences if violated.
So what I've discovered in my time on the planet is whatever problems that people have in their relationships, when they don't unpack that suitcase and address it, it's still there. It's just waiting to come up whenever it wants to come up. So whatever discussion you all were having at that apartment where you told her you didn't want her there anymore, you wanted her to leave, unless you all have addressed that issue, it is still there, waiting to be unpacked. And it's going to be unpacked while you're on probation. And when you're on probation, you're looking at potentially 20 years in the prison if that suitcase is unpacked improperly. Do you understand?
At this time, there's no issues.
So how many children do you have? What are their ages?
16 months and one on the way. 2 months in April.
And it's never great when a couple gets in an argument and then people are calling their family members over, because then that causes confusion. And I read in the report where then her brother's coming over. These other family members are coming over. That's not a good situation to be in. So how are you all addressing your issues? I can't order marriage counseling because I don't have any jurisdiction over her. but how are you all addressing your disagreements?
All I can say is that everything's fine and there's no more disagreements.
Oh, there's disagreements in every relationships. I don't care how people say their relationship is great. Even I'm sure Cinderella and the prince that she ended up with have disagreements. Maybe the mice are tracking in dirt or something. But every relationship people have disagreements. How are you handling those other than the police having to be called or her family members having to be called?
We just talk to each other better, I guess.
All right. Are you employed?
I guess not.
What do you do?
Handle quality and logistics for a box plant.
I'm sorry, what?
I handle quality and logistics for a box plant.
Okay. And what does that mean?
I handle the quality of different fibers for material to make boxes.
Boxes of, you mean just?
Corrugated boxes.
Oh, okay. I'm gonna need to talk to you. My boxes are always breaking down. I'm assuming you're not the person who put the stamp on that box. That's somebody else.
Have quality towards it.
Okay, that's awesome.
What may sound like a casual conversation about relationships is actually part of the judge's sentencing analysis. Texas courts often evaluate the circumstances that led to the offense when crafting probation conditions. The judge is trying to determine whether unresolved conflict, family disputes, or emotional issues could create future legal problems. This focus on rehabilitation reflects the broader goals of community supervision under Chapter 42A of the Texas Code of Criminal Procedure.
And what are your hours like?
I work 7 p.m. to 7 a.m.
Oh, wow. That's the night shift. All right. This is what the court is going to do. $300 fine, probated, 2 years deferred adjudication, 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to do that, but if you do, 40 of those hours will be waived. I'm going to ask for parenting classes, and the remaining of those hours will be waived. Anger management, regular reporting by Zoom or in person, proof of employment within 30 days, no employment as a home health care provider or with minors, regular UAs, and we'll do field visits for 2 months. Probation, if there are no issues with field visits, then field visits can be discontinued. Probation, is there anything else he needs? I'm sorry, and also no contact with Gabriel Artalejo and Aaron Dow. Is there anything else you need from the court to be successful? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Did you sign it?
The judge closes with a lesson that probation officers across Texas repeat every day. Communication is key. Under Texas Code of Criminal Procedure Article 42A.751, probation violations can trigger revocation proceedings that place a defendant back before the court. Many probation cases fail not because of a new crime, but because defendants stop reporting, ignore conditions, or fail to communicate with supervision officers. The judge is making it clear that this deferred adjudication is an opportunity, but it comes with responsibility.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, because I'm sorry, I have notes over here that I'm looking at. All right, in this court, communication is key. You want to be successful on probation, stay in contact with your probation officer. If there's any issue about something you feel you're not receiving or communication is not being answered, we're always here in court. You can come by. All right, good luck to you.
Thank you.
Here you go. All right, Norma. So on these, oh no, tell them to do the pleas. We're going to take our lunch break.